1. Between February of 2014 and February 2019, the plaintiff, Renata DAGGS, was employed as a licensed practical nurse on an acute inpatient psychiatric unit at University Health Conway, who as of October 1, 2018, became OCHSNER LSU Health-MONROE OLHM located at 4864 Jackson Street, Monroe, La 71202. A nonprofit, private-public organization. Parent company is OCHSNER LSU Health Systems of North Louisiana DBABRF. 2. On or about 2016, the psychiatric supervisor requested a printout from the pharmacy, listing the total amount of Haldol, Ativan, Benadryl, HAB injections each nurse administered during a specified time frame. Staff were told that we must increase the number of HABs administered, and if that is a problem, we may need to find somewhere else to work. 3. The nurses refused to comply with orders that violate the rights of patients. In close proximity to paragraph 13, the chief psychiatrist removed Ativan from the series of injections. Ativan was the only effective medication in HAB for an immediate violent situation. 4. The physician's office is 5 feet across the hallway from the day room. In close proximity to paragraph 13, the psychiatrist demanded silence from both patients and staff throughout doctor's call. The psychiatrist did not want to hear any noise. Shish signs were being posted throughout the psychiatric unit. Staff were required to whisper. The activity coordinators were instructed not to play music during the exercise group. For a short period of time, staff were instructed and signs were posted that the television in the day room was to remain off during doctor's call. The unit had only one pair of walkie-talkies. The doctors had one to call for the next patient, and a staff member had the other to retrieve the patient. 5. In close proximity to paragraph 14 and 15, a substantial increase in the amount of patient staff assaults and a substantial increase in the number of HABs administered to patients. 6. Crisis Prevention Institute (CPI) training states that performing periodic drills and maintaining adequate staff is required in order for CPI to be effective. OLH failed to abide by either of those policies, despite the increasing rate of assaults and injuries. Media. 7. More than 10 employees who work in the administration department attended CPI training in the plaintiff's class alone. Neither of these individuals were ever pulled from their department to assist in the assurance that our patients and staff remain safe. Throughout the entire 5 years of my employment, the only people who were ever floated from their department to the psychiatric unit were African Americans. 8. 95% of the assaults were against African American staff and patients. For 2 years, staff begged for Ativan to be added back to the PRN. Between November 14, 2018 and November 19, 2018, 3 Caucasian staff and 1 Caucasian patient were hit. By November 23, 2018, the physician restarted the administration of Ativan to the patients. 9. Our supervisor and the on-campus security informed the psychiatric staff that security could no longer physically assist staff in subduing a violent patient unless the psychiatric staff physically touched the patient first. 10. The company changed the locks on each door of the patient's rooms, giving the patient the ability to lock staff out. The concern was raised numerous times about the ease of obstructing a keyhole and the amount of time it would take to enter the room through alternative means. This decision put staff, roommates, and suicidal patients at risk. Media. 11. The staffing, acuity, calculation policy was changed by our employer, which drastically changed the patient to staff ratio. This change significantly decreased the amount of staff on each shift. Media. 12. Patient's medication was no longer being administered by one nurse inside an encased area. Each nurse became responsible for administering medication to their own patients. The nurses were mandated to remain stationed on the floor versus in the nurse's station throughout their entire shift. A. Neither of the medication laptop carts lock and neither of the batteries sustained a charge longer than 1 hour. The necessity of leaving the cart unattended and providing ligatures to violent patients was inevitable. Staff was repeatedly denied carts that locked and were told that the batteries were too expensive. A battery exploded twice. The fumes permeated the 5th and 3rd floor. Media. B. In close proximity to paragraph 16, the company said that they were over budget and delegated the task of laundering the patient's clothing to the BHTs versus sending them out to be professionally laundered. We were provided a stackable washer and dryer and given 1 Tide Pod only per wash. This was a subject of multiple complaints. Media. Location. 13. 60% of the time the machine was inoperable. The patient's biohazardous clothing, urine, blood, feces, infectious diseases, body lice, etc. would sit around in paper bags. Plastic is not allowed on psych unit. Spores, viruses, bacteria, etc. can outlive and even flourish in wet, warm environments without the use of proper chemicals. The dryer is properly vented, which means the aforementioned is circulating in the air and onto items. 14. Prior to the above paragraphs, every patient was escorted to their individual rooms for toileting needs. This was no longer permitted. Every patient was required to use a one-commode bathroom across the hall from the day room. This caused a number of problems such as A. The patients were not permitted to lock the bathroom door, therefore, patients of the opposite sex were invading each other's privacy. B. This bathroom is in direct view of a camera. This bathroom does not have stalls, therefore, there is no other door to increase privacy. This violates an expected privacy, especially on a psychiatric unit. Their behavior is often unpredictable. C. Patients who were on blood and body fluid precautions were required to use their personal bathrooms, but quite often the patient never alerts staff and use the bathroom everyone else used. D. Other patients would become angry because they aren't permitted to use their clean bathroom. E. Some patients understand why that patient must use their personal bathroom and began broadcasting their assumptions aloud. F. Urine, feces, and menstrual blood was being smeared throughout the bathroom. By the time a more mentally stable patient informed staff about the condition of the bathroom, multiple, unstable, patients had transferred it to the dayroom or other areas of the unit. 25. G. The supervisor mandated that the BHTs use Sani wipes to clean the bathroom between each patient's use, despite the severity of the cleaning that is needed. 15. Between January 2015 and November 2018, the plaintiff made several anonymous complaints to Patient Advocate, OSHA, and Louisiana DHH regarding inadequate medical care provided to psychiatric patients. A few examples are: A. Patient 1 suffered severe chest pains over a span of 2 days. The patient slept on his knees for relief. Despite a history of cardiac complications and pleas from psychiatric nurses, the patient was denied transfer to a medical floor and remote telemetry. The doctor repeatedly stated that the pain the patient was experiencing was GI, not cardiac. Repeatedly ordering the staff to administer nitroglycerin tabs and GI cocktails. The patient was transferred on the 3rd day, but expired within hours. B. Patient 2 awakened and screamed aloud, which awakened his roommate. His roommate and the behavior health tech BHT summoned for assistance from the nurse, but neither nurse responded. When the nurses did respond, they alerted Code Blue. The physician noted that the patient was in rigor mortis. C. Patient 3. A patient was transferred from ICU to the psychiatric unit. The plaintiff was informed that the patient was medically cleared. Upon receiving the patient, the plaintiff discovered that the patient required a life vest at all times. The patient was not wearing a life vest. This patient was not medically cleared. The plaintiff repeatedly reached out to multiple medical staff members for approximately 3 hours. Her shift ended at approximately 2345 and the oncoming nurse continued to reach out. When the plaintiff returned to work the following morning at 0700, the patient was lying on the floor. Expired. D. Patient 4 was brought into the emergency department after being beaten with a bat. His face was disfigured and he had a lengthy bulge across his back. This patient was never x-rayed. Psychiatric nurses requested an x-ray over a span of 5 days. The plaintiff escorted the patient to x-ray. It was determined that the patient's jaw was fractured on both sides. E. Patient 5 remained an inpatient for more than 365 days. After approximately 6 months into her admission, her status changed from judicially committed back to formal voluntary for the duration. A resident stated, "I'm just worried about what's gonna happen when they find out that she's in her on a formal." Despite multiple staff's request, this patient was never given an excursion. 16. On November 9, 2018, the plaintiff was spit at and attacked by a female patient as she walked out of the nurse's station door. A male staff member had to perform a takedown in order to end the attack. 17. On November 10, 2018, the same patient attacked the plaintiff for the second time after she and other staff escorted the patient to her room due to patient's increasingly aggressive and destructive behavior. 42 CFR Section 482. 13E1C. Upon entering the room, the patient physically attacked the plaintiff again, requiring several staff members to restrain the patient on her bed. 18. Approximately 15 minutes after the second attack, the plaintiff walked to the entrance of the female hall to continue administering medication. This location was approximately 20 feet away from the patient's room. Within 2 minutes of reaching this location, without provocation, the patient began briskly walking toward the plaintiff with her fist balled up while simultaneously threatening and cursing at the plaintiff. The patient stood approximately 1 foot in front of the plaintiff and began to draw her fist back. The plaintiff attempted to use the least restricted form of restraint, escalating as needed. Within 20 seconds, the patient was fully restrained, without injury, by several staff. The patient continued to threaten the plaintiff. 4-point restraints were required. 19. The video will show that the plaintiff acted in a manner that any reasonable person would have. The plaintiff was hit, scratched, choked. The patient then jabbed 2 stiletto acrylic nails into the plaintiff's right eye. 20. The plaintiff was escorted from the psychiatric unit to facilities emergency department by the house supervisor, Scott Hillman. Mr. Hillman then escorted the plaintiff to the laboratory for a drug screening. The plaintiff's results were negative across the board for all chemical substances. 21. Immediately, employees of OLH and LUBA began falsifying documents, altering documents, abusing federally regulated programs, and misrepresenting physician for the purpose of denying a workers' comp claim. 22. Through information and beliefs, 1 week after my last attack, the same patient, while still wearing her acrylic nail, nearly beat another nurse unconscious, fracturing her jaw. According to this nurse and other staff, multiple OCHSNER LSU Health-MONROE administrative staff attempted to bully this nurse into not pressing charges against the patient, but the nurse insisted and OLHM acquiesced, but only with the on-site security. The nurse was then pressured into returning to work within 3 days. The nurse stated that the patient was still wearing her stiletto nails and was no longer on one-to-one observation. The nurse stated that she was still forced to stay on the hall throughout her shift, but remained with her back up against the walls when the patient was near her. This nurse stated that within 3 days of returning to work, the patient was discharged home instead of police custody. 23. OLH was aware that the patient threatened to harm me if she saw me in the streets. This patient has multiple convictions in multiple states for assaulting police, carrying a concealed weapon by a convicted felon, attempted arson to occupied structures, and others. By her own hands, she ignited herself a fire, completely disfiguring herself from her torso up. 24. Michael Solon Austin, a physician's assistant, in OLHM Ed, provided medical treatment on November 10, 2018. His initial diagnosis was forced trauma to the right eye, 1/4 of the right eye's cornea was scratched off, abrasion, and a 1 mm defect to the opposite side of the right eye's cornea. The size and diameter is consistent with a puncture. Mr. Austin scheduled the plaintiff for an eye appointment at OLHM Eye Clinic for November 13, 2018. 25. After obtaining the Austin's notes from LUBA in December 2018, the plaintiff discovered multiple recreated documents, omission of medications prescribed. This medication is very toxic and was illegally dispensed. Falsely documented normal clinical findings with any eye injury, such as no red eyes, no pain, no decrease in vision, previous eye injury. 26. On November 13, 2018, I attended the appointment at OLHM's Eye Clinic. 4 healthcare workers stated that the plaintiff needed to see an ophthalmologist. Dr. Aschenbeck is who treated me and discharged me. Unbeknownst to me, she was not an ophthalmologist. She was a Louisiana State University ophthalmology resident. 27. Over the following 2 weeks, both Tamika Sison, LUBA claim adjuster, and Michael Watson, OLHM risk management, repeatedly misrepresented Dr. Aschenbeck. OLHM repeatedly changed the treating physician's name on the medical bill, from resident Dr. Aschenbeck to the attending physician, Dr. Flynn. There was never a male assisting Dr. Aschenbeck at any point throughout my visit. This change is what alerted me, and approximately 2 weeks later I discovered who she was. The LSU website has Dr. Aschenbeck listed as PYG4. OLHM listed her as PYG2. 28. She performed contraindicated examinations. Documented the healing stage of my eye, without performing the proper examinations needed to make those statements. She documented that my vision has improved, although my acuity had drastically declined from 20/50ths to 24/100ths in less than 72 hours. Although my right eye vision was 24/100ths, Dr. Aschenbeck denied my request for the following weekend off, denied my request for corrective lenses without revealing that her qualifications does not permit her to prescribe corrective lenses, and she failed to refer me to an eye specialist. Dr. Aschenbeck performed in the capacity of an ophthalmologist. The plaintiff's role was as a patient, not an employee, therefore, patient's rights were also violated. 29. Dr. Flynn did not sign off on the plaintiff's visit until November 14, 2018, which legally indicate he did not assist in my care, and Dr. Flynn failed to contact the plaintiff when he saw the visual decline. The patient's right eye acuity is permanently 20/80ths. With full knowledge that Dr. Flynn was never in my presence on November 13, 2018, OLHM submitted the bill to LUBA and LUBA paid the bill. 30. OLH immediately began penalizing the plaintiff with leave without pay, unauthorized absences, and PTO usage was denied throughout 2 pay periods until the plaintiff agreed to sign documents that employees never had to sign to use PTO. OLH later used these documents against the plaintiff in the workers' comp case, stating the plaintiff opted to use PTO, therefore she was not entitled to be paid twice for the same day. 31. The days I was initially penalized included the day of my injury and the following day. The plaintiff's doctor's excuse was provided by OLH Emergency Department on November 10, 2018. The plaintiff received her employee file from OLH and LUBA's workers' comp defense attorney in mid-2019 prior to the workers' comp trial. In those files were a second recreated doctor's excuse, completely different from the excuse the plaintiff received on November 10, 2018. It was scripted in a manner that justified paragraph 40. 32. OLH and LUBA submitted two separate first injury report insurance documents, over wire, stating that the plaintiff had returned to work. One stated that I returned to work on November 11, 2018, and the other stated November 16, 2018. The plaintiff has never worked at OLH since November 10, 2018. There are multiple false entries on those documents and others. 33. The plaintiff filed a small claim suit against Michael Watson for his intentional actions that aided in some vision loss, financial and emotional stress through physician misrepresentation and multiple misleading actions. The plaintiff is a patient and employee. This suit was against Mr. Watson only, not OLH. OLH condoned Mr. Watson's actions and provided him legal counsel. Lawrence Petiet, letter dated February 11, 2019. 34. On November 15, 2018, the plaintiff obtained legal representation from workers' comp attorney, Dustin Flint. He and Todd Watson, risk management, advised the plaintiff to apply for FMLA and workers' comp for the psychiatric portion of the claim, which will also provide job protection in conjunction with workers' comp. After I was approved for FMLA, I was then told by Savannah Bagwell that my workers' comp case was closed on November 20, 2018. My vision loss was not caused by my eye injury, therefore they are not responsible for paying for the eyeglasses Dr. Barron prescribed, nor will I receive any workers' comp benefits. Sison, Watson, and Bagwell stated that Dr. Barron said my office visit on November 19, 2018, was a yearly visit. FMLA would only apply to the psychiatric injury, which would only allow me to use PTO and ESL 29C. F. R. Section 825. 207E. 35. Bagwell and Watson willfully and intentionally used a federal program, FMLA, to mislead the plaintiff. OLH and LUBA were informed by the plaintiff that she was 30, not mentally prepared to return to work so soon because of the number of attacks that occurred and the uncertainty of full restoration of vision in her right eye. Job modification was never offered. LUBA refused to pay for the visit for psychiatric treatment, mileage reimbursement, or pay for the prescription. The words, workers' comp, was written on the top of the FMLA form, which also misled the physician. The plaintiff's workers' comp case was not closed. 36. OLHM provided the plaintiff with FMLA documents, stating that the psychiatric injury I would be taking time off for would also be filed under workers' comp. Workers' comp is written on the top of the form. Upon returning the FMLA forms to OCHSNER LSU Health of Monroe, Savannah Bagwell, Human Resources, told me that I would only be approved for FMLA. Dr. Barron said that my eye injury did not cause my vision loss and that my visit to his office was a yearly appointment, that the company will not purchase the eyeglasses nor provide workers' comp benefits, and that my workers' comp case was closed on November 20, 2018. The evidence will show that every statement Mrs. Bagwell made was false. Over a week has lapsed between the time I initially spoke to Mrs. Bagwell regarding the above and the day that created the correspondence restating these false statements. This was an intentional misrepresentation of facts transcribed onto a document involving a federal program. Notes from Dr. Barron's office will show that they were instructed to bill my visit as a yearly visit and where to send it. January 8, 2019 is the day I called my employer, requesting the verification of Mr. Watson's first name to file a small claim suit against him. I was denied his legal name. 37. LUBA Mutual Holding Company was and is the secondary processor of the plaintiff's workers' compensation claims regarding an incident that occurred on November 10, 2018. OLH, primary processor. 38. Attorney Walter Sally legally represented LUBA and OLHs in regards to the plaintiff's workers' comp claim. 39. Tamika Sison was employed by LUBA between November 10, 2018 and January 4, 2019. 40. Lisa Robbins was employed by LUBA between January 8, 2019 and February 8, 2019. 41. Sarah Ulmer was employed by LUBA between November 13, 2018 and November 14, 2018. 42. LUBA aided and abetted or knowingly and willfully permitted their employees to use the United States Postal Service to transfer documents that contained falsified and or altered information regarding the plaintiff's workers' compensation claim. Media. 43. Luba aided and abetted or knowingly and willfully permitted their employees to use electronic devices to transfer documents that contained falsified and/or altered information regarding the plaintiff's workers' compensation claim. Media. 44. Luba aided and abetted or knowingly and willfully permitted their employees to use electronic devices to verbally make false statements regarding the plaintiff's workers' compensation claim. Media. 45. Luba employees failed to investigate, report, and/or properly correct fraudulent activity after being informed with specification. Media. 46. The plaintiff's phone number was blocked after she insisted on speaking to Sizen's supervisor and requesting to be examined by another ophthalmologist separate from OLH. Media. 47. Luba employees and another defendant jointly violate plaintiff's well-established constitutional rights in an effort to deny plaintiff's workers' comp claim through illegal, capricious, and arbitrary means. I.e. the January 9, 2019 denial letter stopped short of, in an unprovoked. Media. 48. Luba paid an insurance bill with knowledge that Dr. Flynn did not perform or assist in medical services rendered to the plaintiff on November 13, 2018. Media. 49. On November 13, 2018, the plaintiff was a patient at OCHSNER LSU Health-MONROE. On November 13, 2018, Dr. Kyla Aschenbeck was an ophthalmologist resident at LSU Medical School. 50. On November 13, 2018, Dr. Flynn was Dr. Aschenbeck attending 51. Information and beliefs throughout. November 13, 2018, Dr. Flynn was performing surgeries. 52. On November 10, 2018, the plaintiff's right eye acuity was documented as 20/50ths. On November 13, 2018, Dr. Aschenbeck documented the plaintiff's right eye acuity as 24/100ths, but Dr. Aschenbeck documented that the plaintiff's vision had improved since on November 10, 2018. 53. On November 13, 2018, Dr. Kyla Aschenbeck A. treated and discharged the plaintiff without summoning the attending. B. failed to refer the plaintiff to an eye specialist. C. falsely documented. D. performing out of her scope of practice. E. violated the plaintiff's patient rights. F. committing medical battery by using a tonopen, which is a contraindication to the type of injury the plaintiff suffered. G. ordering that the plaintiff continue using all medications prescribed on November 10, 2018, including tetracaine, a very toxic eye anesthetic. H. failed to follow physician's order that stated the plaintiff must be seen by an ophthalmologist. 54. Between November 2018 and January 2019, the plaintiff informed Louisiana State University multiple times of Dr. Aschenbeck's performance on November 13, 2018. 55. LSU alumni workers' comp insurance is through Luba. 56. On November 16, 2018, the plaintiff and attorney Dustin Flint agreed to an attorney-client relationship for the workers' comp case. 57. In our initial conversation, we discussed the eye injury, psychiatric injury, Luba blocking my phone number, which prevented the plaintiff from obtaining a prior approval from Sizen. 58. Tamika Sizen made several false and unethical statements which led the plaintiff to seek legal counsel, such as, told me that she must approve all healthcare visits prior to scheduling appointments, the healthcare provider must be an ophthalmologist because it was an ophthalmologist that released me back to work on November 13, 2018, that if an opthal, the plaintiff asked Mrs. Sizen, if the physician prescribes corrective lenses, will they pay for them? She verbatim, we don't have to pay for anything, we'll just send you to one of our doctors, et al. 59. The plaintiff emailed attorney Flint regarding the FMLA forms given to me because at this time, OLH and Luba had been deceitful. His response was fill it out and turn it in. 60. Between November 16, 2018 and December 6, 2018, documents were falsified. OLH refused to pay workers' comp benefits. OLH refused to pay PTO. OLH refused to purchase the eyeglasses prescribed by Dr. Barron, wrote multiple adverse remarks on my attendance, and told me that my workers' comp case was closed on November 20, 2018. 61. I immediately informed attorney Flint of this information via email. He replied, don't worry, he was going to take care of it. 62. On December 6, 2018, I was told by Mrs. Sizen that Luba was never ever contacted by attorney Dustin Flint or any attorney on my behalf and that they were not aware that I had any. 63. I emailed attorney Flint and he immediately contacted me via phone, stated that Mrs. Sizen was lying and that he did contact her. 64. On December 6, 2018, Mr. Flint sent an email to Luba informing them that he was representing the plaintiff. The plaintiff received a text message from Mr. Watson stating that he can no longer speak to her because the plaintiff has retained legal representation. 65. Attorney Flint stated to the plaintiff in an email that the defense had not done anything wrong and that the psychiatric claim was new. 66. Attorney Flint stated that the plaintiff would have to resign to receive any workers' comp benefits. 67. On or about December 13, 2018, Attorney Flint and the plaintiff ended their attorney-client relationship. Upon receiving the letter via mail 47HL, the plaintiff observed in the document that no further legal actions will be provided by Williamson Fontenot Campbell and Whittington LLC or Dudley DeBosier Law Firm. 68. Gregory Unger became involved when the workers' comp defense attorney, Walter Sally, solicited him to represent the plaintiff. Media. 69. On or about March 10, 2019, I received a call from Mr. Greg Unger stating that he was willing to represent me. I had not called Mr. Unger specifically, but he was a part of Workers' Compensation, LLC. And I had reached out to 2 specific attorneys, but was never contacted by either. 70. He said that he would send me the contract and we would go from there. When I got the contract packet, it was accompanied with a letter sent to Luba stating that he was now representing me. The letter told me not to speak to anyone about the injury or case. 71. Within a few weeks, the plaintiff received a letter from Mr. Unger stating that the deposition had been rescheduled from April 2, 2019 to April 16, 2019 and the location was moved from Monroe to Mr. Sally's office in Shreveport, Louisiana without contacting the plaintiff FRCP 30. 72. The plaintiff called Mr. Unger and asked would I still be able to ask questions or have a deposition set up because as of that day, I still have not seen the video or have been forwarded in part of my files since December 22, although I had made several requests written and audio available. Attorney Unger was extremely rude stating, first of all, you didn't tell me that you were in litigation. I'm gonna do this the way I want to do this. If you're trying to do something different. All I do is workers' comp, nothing else. I'm not paying for no deposition. They are expensive and you are gonna pay for it, not me. We got the video, I don't think you have anything to worry about. 73. In mid-March I sent Mr. Unger an email asking would it be okay if I sent those documents previously mentioned to LSBPNE because they have a time frame that nurses must respond to the accusations. Unger never responded and I didn't hear from Mr. Unger until April 15, 2019, the day before the deposition. 74. I won't be there. I'm not driving 10 hours for a deposition. It doesn't make any sense for me to. He then proceeded to tell me that the medical review panel has nothing to do with workers' comp, therefore it was pointless to add it in the files I sent to him. He also told me that he and Walter Sally were old buddies and that he interned with Sally. 75. On April 16, 2019, the day of the deposition, Attorney Unger never spoke to me and greeted Mr. Sally with, "Hey buddy." 76. Mr. Unger allowed Mr. Sally to perform multiple vision acuity examinations. Attorney Sally has no qualifications in doing so. This was not a video deposition. There were no distance measured, font size, or font background color recorded. 77. During the call with Attorney Unger the evening before the deposition, he stated that the medical review panel does not pertain to this workers' comp case. During the deposition, Attorney Sally turned to Eileen McLean and asked her if there was anything else she wanted him to ask. Mrs. Eileen slid a notepad to him and pointed to it untranscribed. Attorney Sally began asking me questions about the EEOC complaint, the small claims suit against Watson, and the medical review panel. I asked Mr. Unger if I was supposed to answer those questions. Attorney Unger replied, "Answer any question he asks you." The court reporter rephrased Unger's response. 78. Attorney Sally asked the plaintiff if I had an attorney for the EEOC. The court reporter transformed this entire line of questioning. 79. At the end of the deposition, he instructed me that most people who are deposed do not read the transcript, so the plaintiff declined. Attorney Sally asked Unger if he wanted a copy of the transcript. Unger replied, "No." 80. The court reporter transcribed the question and answer presented to the plaintiff, but did not transcribe the question to a response from Unger. 81. Attorney Unger never spoke another word to me. On April 18, 2019, I received a large manila envelope from Attorney Unger, date April 16, 2019, the same day of the deposition. 82. The manila envelope contained copies of documents I forwarded to Attorney Unger and a letter stating that he was withdrawing from my case attached. 83. Unger's reasons were false, capricious, arbitrary, and revealing. 84. Unger knew a 1008 had been filed. 85. EEOC and LSBPNE appears to be Unger's focus also. 86. Unger's letter stated that the only reason he took the plaintiff's case was because his friend, Attorney Sally, called him and asked him to. 87. Unger stated that this was a small claim versus no claim. 88. Unger mentioned, amicable, yet never offered a settlement of any kind. 89. Unger was aware that the plaintiff had been previously represented. No attorney has ever spoken to the plaintiff without establishing representation status and release letter. 90. Reference 47 FD. The file did not contain the video nor did it contain any new information provided by the defense. 91. The deposition conference call ended with Unger prior to the plaintiff leaving attorney Sally's office. Unger never spoke to the plaintiff after the deposition, and Unger dropped the plaintiff on the same day of the deposition, yet he and Sally scheduled a pre-trial hearing. 92. The plaintiff requested several times for Mr. Sally to return the interrogatory forwarded to him but failed to do so. This failure to return the interrogatory was also a violation of the orders by the workers' comp J. 93. On record, during the workers' comp trial, attorney Sally vehemently denied ever speaking to attorney Unger as stated in paragraph 47 FOE. Eventually Judge Jones stopped attorney Sally, replying, "I read the letter." Attorney Sally did not say anything else. 94. Attorney Sally knowingly and willfully used the United States Postal Service to transfer documents that contained falsified and/or altered information regarding the plaintiff's workers' compensation claim. Media. 95. Attorney Sally knowingly and willfully used electronic devices to transfer documents that contained falsified and/or altered information regarding the plaintiff's workers' compensation claim. Media. 96. Attorney Sally knowingly and willfully made false statements during a legal proceeding. Media. 97. Sally submitted documents to the WJC that he would be submitting documents from the Oaks nursing home with complete knowledge that police records, audio recordings, and documents that contradicted the validity of the statements in those records. 98. During the deposition, Mr. Sally asked me about the names of the medical facilities I had received treatment. He had a list of names in front of him, yet he asked the plaintiff if she had said, "STD, clinic," at which time Eileen McLean appeared to be holding back a laugh, then spun her chair around toward the window. At this time, the court reporter appeared to have become annoyed at Sally and Unger actions and blurted out, "She said SD Hill." The transcript will show that the court reporter had typed the name of the clinic prior to Sally asking. The evidence will show that neither OLH nor attorney Sally any has respect for acts against women and children and the privacy thereof. 99. From March 8, 2019 through October 2019, Marian Ansardi was the executive director at Louisiana State Board of Practical Nursing Examiner (LSBPNE). 100. From March 8, 2019 through October 2019, Patorny Saucier was a compliance officer at Louisiana State Board of Practical Nursing Examiner (LSBPNE). 101. Judge Glenn Ansardi is the Chief Justice over 24th Judicial District Court of Jefferson Parish. 102. 37 Section 963. The domicile of the board shall be Jefferson Parish, Louisiana. 103. Appeals from decisions of the board shall be to the 24th Judicial District Court of Jefferson Parish. 104. The 24th Judicial District Court of Jefferson Parish workers' comp insurance is through LUBA. 105. On March 8, 2019, the plaintiff informed OLHM that an EEOC complaint was being filed for wrongful termination et al. 106. On March 8, 2019, Marian Ansardi composed a letter from stating the plaintiff's nursing license was summarily suspended, effective March 8, 2019 regarding the incident that occurred on November 10, 2018. This is a violation of administrative law because I was never given a show cause hearing or any communication prior to summarily suspending my license. 107. The letter stated defense: the plaintiff was the aggressor in a physical altercation with a patient. The video shows the patient walking approximately 25 feet toward the plaintiff, with her fist balled up. 108. The video is audioless. There were 6+ employees present. Neither Mrs. Ansardi nor Mrs. Saucier obtained one witness statement to establish verbal threats, an intricate factor when determining the aggressor. Media. 109. The letter stated defense: the patient drew her hand back but never swung at you. The video shows that the patient drew her fist back. DHH, Louisiana State Law, U.S. Constitution, and CPI regulations permits physical contact when imminent danger presents itself as an affirmative defense. Any reasonable person should know that no person can ever be ordered to stand idle until they are hit first. LA Section 1419. Closing parenthesis. 110. The letter stated defense: the plaintiff aggressively grabbed the patient by the shoulders and pushed her into the wall, creating an altercation that ended up on the floor. Evident by the gap in the patient's shirt, the video shows that the plaintiff grabbed the patient's shirt in an attempt to regain personal arm's length space. The patient then bent forward to strike the plaintiff in the face, which caused the patient's buttocks to make contact with the wall first. These events took place prior to the patient's upper torso touching the wall. Another employee began assisting prior to the patient's shoulder making contact with the wall. 5 employees performed the takedown after the patient stabbed the plaintiff in her eye with 2 stiletto fingernails, then proceeded to choke the plaintiff. Media, 111. The plaintiff remained engaged with the patient and holding her down. 20 seconds elapsed between the time the patient began walking toward the plaintiff to the time the plaintiff was no longer touching the patient. Approximately 5 seconds after the takedown, the plaintiff's body was no longer restraining the patient because the patient had stopped physically struggling. The plaintiff is required to reestablish communication with the patient. The plaintiff is required to reassess the patient's behavior before placing her in 4PT restraint. If she had refrained from verbal threats, the patient would then have the right not to be restrained any further. Media, 112. The letter stated defense that drug and/or alcohol was a possible factor. LSBPNE had full knowledge that the plaintiff's November 10, 2019 drug screen was negative for all chemical substances. 113. The letter stated defense possibly being unfit or incompetent by reason of negligence, habit, or other causes. Ansardi had nothing from anyone stating that the plaintiff had any prior complaints of any kind. 114. The plaintiff's annual evaluation on November 9, 2018 echoes exceptional work performance prior to the incident. A January 28, 2019 letter from OLH regarded the plaintiff's return to work. 115. The letter stated defense Louisiana Revised Statutes 49, 961C, and the board has determined that the allegations against you are sufficiently serious to summarily suspend ULPN license. Physically assaulting a patient is illegal. Without any evidence to support allegations, Mrs. Ansardi summarily suspended the plaintiff's license, but no criminal charges were pressed. 116. In this letter, Ansardi had already predetermined that the board will schedule your case for the next available formal hearing and will notify you by mail of the date and time. 117. According to Louisiana Revised Statutes 37 Section 969A4. Duties and powers of the board shall conduct hearings upon charges calling for discipline of a licensee, or for revocation, denial or suspension of a license issued or applied for under this part upon proof that the person, AG. 118. Between March 8, 2019 and June 21, 2019 Mrs. Ansardi received the CPI guidelines, police reports, audio recordings, witness statements, DHH guidelines, state laws, federal laws, evidence that OLH was acting out of retaliation, et al. Regarding all allegations made against the plaintiff. 119. On June 21, 2019 Mrs. Ansardi composed a formal complaint letter regarding the plaintiff upcoming hearing. 120. The letter dated June 21, 2019, was transported to the plaintiff via the United States Postal Service, certified mail. 121. In the letter dated June 21, 2019, Mrs. Ansardi willfully and knowingly documented multiple false and misleading allegations against the plaintiff. 122. The letter stated that the major issues were criminal charges the plaintiff reported to the board while attending nursing school in 2008. 123. LSBPNE knew that I was never formally charged with anything. 124. LSBPNE know that my criminal record is spotless and that the plaintiff has never had anything expunged off her criminal record. 125. The incidents that LSBPNE are speaking of was in 2004, 2006, and 2008. The plaintiff has never been formally charged of anything and certainly never convicted of a crime. 126. The plaintiff upbringing was very hard. LSBPNE received a detailed statement regarding these incidents from the plaintiff during her early months in nursing school. These incidents involve the plaintiff's family and are very private and hurtful matters. Child abuse, child rape, incest, domestic violence, et al. 127. On May 14, 2019, workers' comp defense attorney Walter Sally sent a subpoena for deposition and subpoena duces tecum to my former employer, the Oaks Nursing Home. 128. On May 15, 2019, Mrs. Saucier sent the plaintiff a very threatening and intimidating letter demanding that the plaintiff provide her with information that the board has authority to request. 129. You must keep the board informed of the name and address if you gain new employment. In addition, until this investigation is concluded, you are required to inform the board of present employment and any changes in employment. 130. The plaintiff called Mrs. Saucier in reference to the information she was demanding in the letter and the threats of what would happen if the plaintiff did not comply. Mrs. Saucier admitted that she did not have any authority to demand job information that does not pertain to patient care. 131. The May 15, 2019 letter also involved 2 incidents during the plaintiff's employment at the Oaks Nursing Home. The plaintiff provided Mrs. Saucier with crucial information and evidence against the nurses involved regarding severe patient abuse, obstructing justice, giving false statements to police officers, embezzlement, child abuse, negligence, conspiracy, false witness statement, etc. Mrs. Saucier stated, "We're not investigating them, we're investigating you. These nurses were Caucasian." 132. The LPN, a charge nurse who wrote the plaintiff up because she did not sign one patient's medication administration records while still administering medication, was under investigation and was upset with the plaintiff because she would not illegally sign documents to assist her in the investigation. The plaintiff resigned, and within 1 month that charge nurse was fired for embezzlement, stealing time, etc. The Don and Aden called the plaintiff and rehired her a few days later. Approximately 3 months later, the former charge nurse, who was still working as a nurse, was in a police blotter while wearing her nursing uniform for beating her daughter. LSBPNE completely removed this incident from their investigation and never mentioned it again. This former charge nurse is Caucasian and continued to practice as a nurse. 133. The letter also contained an incident that occurred in December 2014 regarding a disagreement between the plaintiff and another LPN/LPNR. Closing parenthesis. 134. The board states that they do not investigate interpersonal conflicts. 135. LSBPNE is very aware that LPNR suffers from a severe mental illness which prevented her from practicing for approximately 4 years. 136. The plaintiff provided Mrs. Saucier with police reports, audio recordings, and written statements from the head administrator, witnesses, and LPNR. Stating that the plaintiff never did or said anything threatening. "I was never suspended. The yelling occurred when that LPN physically assaulted another nurse and then a police officer." 137. On July 1, 2019, Mrs. Saucier sent the plaintiff a letter stating, "The phone call recordings must be substantiated in order to include them as your response, although one of the documents they were using was written multiple days after I was cleared and resigned. That call was also recorded and contradicts that document. Also, the letter could not be substantiated because the writer died in 2017. I had no knowledge that the document existed. I also have 2 recorded calls by Julie Arendt, a signature on that document, and of a Caucasian male nurse, attempting to force a CNA to sign a document that would blame me for the abuse that he had committed against a patient. What they were attempting to do is criminal." LSBPNE refused those audio recordings as well. LSBPNE chose to use attorney John Becknell as their administrative judge. This attorney and his law firm has an extensive history in unethical practices and, according to the OIG Causeway investigation, admit to his involvement regarding the Causeway, quoting, "This is how it has always been done." Quote. 138. The accusations that Mrs. Saucier demanded an explanation for was unsubstantiated, yet was allowed to be entered in as evidence. This is a violation of Louisiana CCP Art. 1636. More specifically, Louisiana CCP Art. 1636d. If the court permits a party to make a complete record of the evidence held inadmissible, it shall allow any other party the opportunity to make a record in the same manner of any evidence bearing upon the evidence held to be inadmissible. The documents and through information and beliefs, Mrs. Ansardi misused their unlicensed employees to send malicious correspondence and perform illegal actions against the plaintiff to preserve the integrity of her own nursing license. There is a pattern of healthcare facilities using nursing boards as slave owners, and the nursing board using the license of healthcare providers as whips to strike fear, retaliation, and mutism into healthcare providers. It's criminal. In November 2019, LSBPNE revoked my license and billed me $3,000. There is no inference or speculation that every allegation is false, including that my workers' comp claim was denied because I was the initial aggressor. I was offered a settlement and chose what they were and were not going to pay. The remaining bills were put on my credit report. The state of Louisiana allowed this. Workers' comp was denied because I was unable to pay for the certification of documents. 139. During the deposition that took place on April 16, 2019, Jane Reeves transcribed stipulations that did not take place during. 140. During the deposition that took place on April 16, 2019, rephrased statements during the deposition. 141. During the deposition that took place on April 16, 2019, failed to transcribe statements made by parties during the deposition. 142. Within 5 months of the deposition, the plaintiff received a copy of the final transcript. The plaintiff immediately observed discrepancies and via email to attorney Walter Sally, requested the audio to the deposition. A return email directed me to call the court reporter. After multiple days of speaking to employees at Karen Tyler Staffing, the plaintiff was informed that the audio recording was no longer available. 143. OLH also breached an FMLA contract with the plaintiff for a psychiatric injury that a physician linked to the 3 attacks that caused my eye injury. 107 Stat. 929 U.S. C. Section 2612 of 1 C. Michael Watson, OLHM Risk Management, and Savannah Bagwell, OLHM HR stated W on November 30, 2018, OLH informed the plaintiff via USPS, FMLA will expire upon the use of 480 FMLA hours. Your physician has indicated your anticipated return to work date will be February 10, 2019. Your workers' compensation claim ended on November 20, 2018 when your doctor released you to work. PTO and then extended sick leave will be used for all medical incapacity. Once PTO and ESL is exhausted, your leave will be unpaid. My workers' comp case was not closed. A doctor has taken me off work for the incident that occurred on November 10, 2018. PTO cannot substitute workers' comp benefits. 29 C. F. R. Section 825. 207E. Another 2 weeks would pass before OLH allowed the use of PTO, and OLH willfully and knowingly deceived the plaintiff and the physician by verbalizing and writing workers' compensation across the top of the FMLA forms. OLH refused to file an workers' comp claim or pay for medical treatment from a psychiatrist, although the referral deemed necessary by the physician. This is one of many misuses of the federal government to aid in OLA's unconstitutional tactics, fraudulent use of a federal program. Alternatively, the plaintiff along with all other psychiatric nurses worked 36-hour work weeks, which would have provided 13 weeks if calculated within 480 hours. This timeframe would have provided FMLA end date on February 6, 2019. 29 C. F. R. Sections 825. 300D 4D 6. 144. On January 28, 2019, OLH informed the plaintiff via USPS that her FMLA coverage had ended. The letter stated, your leave, which began on November 10, 2018, will end February 10, 2019. OCHSNER LSU Health D. B. A. University Health has accommodated the physician's request of being off of work for a full 3 months. This accommodation goes beyond the prescribed timeframe under FMLA of 12 weeks. 29 C. F. R. Section 825. 229 C. F. R. Section 825. 702 A. Title 7 of C. R. Act of 1964 FMLA Interference. Laffey v. Northwest Airlines, Inc. 567 F. 2D 429, 445D. C. CIR. 1976 Cert. Denied, 434 U.S. 1086 1978, 145. On February 6, 2019, OLH terminated the plaintiff. The hospital policy stated that they provide 12 weeks of FMLA leave per year. By law, the plaintiff's allotted time to extend FMLA is March 23, 2019. 29 C. F. R. Section 825. 200B 129 C. F. R. Section 825. 200 C and 29 C. F. R. Section 825. 200 D 1. 29 U. S. C. Section 2615 Prohibited Acts, 29 C. F. R. Section 825. 220. Specifically, 29 U. S. C. Section 2652 and 29 C. F. R. Section 825. 700. The plaintiff filed a complaint with the Department of Labor, Wage and Hour Division. 146. Between 2016 and October 2019, the following Louisiana government oversight agencies were notified of the above-mentioned. Each agency had a duty to investigate the complaint, contact the person filing the complaint if the information was provided, and investigate the entity or person that the complaint was filed against. A. Louisiana Department of Health and Hospitals. B. Louisiana State Bar Association. C. The Ethics Committee Board. D. Louisiana House of Representatives, Committee on Senate and Governmental Affairs. E. Louisiana Senate, Committee on House and Governmental Affairs. F. Louisiana Insurance Commissioner. G. NAIC. H. Occupational Safety and Health Administration. I. Louisiana State Board of Practical Nursing Examiners. J. Louisiana Department of Labor. K. Louisiana Workforce Commission. L. Louisiana State University. M. Louisiana Board of Examiners Certified Shorthand Reporters. N. Louisiana Attorney General. O. Louisiana Department of Administration. P. Louisiana Department of Labor. Q. Louisiana State Police. R. Louisiana Medical Review Panel. S. Center for Medicare and Medicaid Services. T. Louisiana Federal Bureau of Investigation.